Welcome back to the Emily Show, the Monday edition. Kind of quick bits, quick-ish, quicker bits. This week, we need to talk about the fact that Diddy has been denied again. Judge Judy is suing because of the Menendez brothers and their resentencing got rescheduled, and the YSL case actually went to the jury. Plus, Judge Cannone in the Karen Reed case did make a few rulings, but not nearly all of them. So let's talk about it. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. Before we get all the way into today's episode, I just have to remind you that if you don't have the Lume app, you are missing out on all of the court coverage goodness on both the Quick Bits channel and on the Emily D. Baker live streaming channel. When this episode drops on Monday, December 2nd, I will be covering live the sentencing for Sarah Boone. You may remember Sarah Boone was convicted of the second-degree murder of her boyfriend when she zipped him into a suitcase and left him there despite him telling her that he was in distress, that he couldn't breathe, and her recording her mocking him. She was fairly swiftly convicted in Florida, and her sentencing is the afternoon this episode drops. So if you don't want to miss a thing, LaunerDapp.com and get all your court notifications, because there are a lot of court hearings coming up in early December before all of the judges are like, pause. It's the end of the year. Give us a minute. But I imagine we'll see a few more rulings coming in quickly in the cases I've been following closely. Just like the Diddy judge dropping an order at the very last possible second on Wednesday before court was closed for the Thanksgiving holiday. Like that. But over in Los Angeles, they have a new district attorney being sworn in early December after a rousing defeat of the very unpopular district attorney there, George Gascon. So Gascon had been holding a lot of press conferences regarding the Menendez brothers and their resentencing. Remember, the Menendez brothers were convicted after a second trial of the special circumstances murder of their parents. There has been quite a lot of information about them. There's been more coverage in docuseries and the like, and there are a couple different avenues that this case is moving forward at this time. There is the habeas petition, which is a, hey, judges, we need you to take a look again. There's new evidence. We need a new trial. Then in the state court level, there is a motion for new trial and a motion for resentencing. The resentencing is what Gascon had talked about the most, but that hearing was set for December 11th, which is after Gascon will be out of office, and the new incoming DA, Nathan Hochman, has been quite critical of why now from George Gascon, because the petitions for resentencing and the habeas petition and others had been with Gascon for well over a year before he ever discussed this case, and seemed to be discussing it in connection not only with his campaign, but in connection with more headlines about the case because of the docuseries. To the Menendez brothers, I'm sure they don't care why one particular DA is looking at their case. If it means a chance at resentencing, I'm sure they don't care what the motivation is behind that. But as we had talked about with George Gascon asking for the resentencing date, he had indicated, and Mark Garrigus had indicated in different press conferences, that within the district attorney's office of Los Angeles, there was a divide of opinion about the resentencing in this case. An incoming DA, Hochman, has indicated that he wanted more time to review the entirety of the file, and that's exactly what has happened. The judge that was to hear the resentencing hearing has pushed that off until January 30th. So we won't even see the hearing happen until the end of January, and that hearing will not have anything decided that day. It's something that the judge is going to hear and then probably research and take under submission. But in a story I was very surprised to see, Judge Judy actually filed a defamation suit over the Menendez brothers case, and this case is still moving forward. She sued the National Inquirer over statements they said she made about the Menendez brothers. This lawsuit was just filed in May 2024 and is now been removed to federal court, originally filed in state court, and is winding its way through the federal system, but is not set for trial until late 2026. Very little actual litigation has happened in this case other than moving it from state court in Florida to federal court. The National Inquirer is alleged to have said that Judge Judy was advocating for Lyle and Eric Menendez. She said that the front pages of both the print and digital editions of the National Enquirer had a photo of her saying things like, "True crime, Judge Judy's fight for Lyle and Eric," and, quote, "baloney." Seriously, National Enquirer? Quote, "baloney, Judge Judy on warpath to save Menendez Brothers." She also alleged that In Touch Weekly, which is published by the same publishing group that publishes the National Enquirer, put an article titled, quote, "Inside Judge Judy's quest to save the Menendez brothers nearly 35 years after their parents' murder." The lawsuit says that Judge Judy was floored to read these headlines, that she had never made such statements, and the National Enquirer was attributing statements to her that were completely fabricated. She also said that these statements made strike at the heart of her good reputation and are especially damaging because they put forward a position that she has not taken and does not take. And she doesn't really take a position on any cases in the news. She just covers the cases that come before her in court. So on this, Judge Judy is called BS. And I'm going to keep following the defamation case of Judge Judy versus the National Enquirer. Let me know if you're interested in more of a breakdown of this case. If you've been following along with my coverage of the YSL case, I did talk about Young Thug, aka Jeffrey Williams, or vice versa, taking a plea deal. Many of the defendants that were on trial had pled out in that case. Originally, 7 defendants went to trial, then it was down to 6. But this is of 28 defendants that were charged in this overwrought RICO case. You will remember that this trial started jury selection in January 2023 and started opening statements in November 2023. And at the end of November 2024, the jury finally got the case as to the 2 remaining defendants in this trial. Remember, of the other indicted defendants, some have still not gone to trial yet. The jury has been deliberating about 2 days when they took a break for the Thanksgiving holiday, and they will be back on Monday, December 2nd. I'm sure the defendants who took plea deals are quite nervous to see what happens with the defendants that have remained on trial. And I will be keeping an eye on what the jury decides as to defendants DeMontre Kendrick, also known as Yak Gotti, and Shannon Stillwell. And then a quick update in the Karen Reed case, because Judge Cannone made a few rulings. You know what Judge Cannone didn't rule on? Whether this is going to trial in January or whether she's going to grant the continuance. That is still looming. But if you remember from the discovery hearing I covered last week on the live stream channel, one of the things that was brought forward was the prosecution's request for phone records from Karen Reed's father and from Karen Reed's mother. The argument made by the prosecution was that Karen Reed called her parents at 1:30 in the morning. This was unusual, and the prosecution argued that she called her parents at that time because she knew she had done something wrong or bad. And so that's why she was calling her parents, and that was an unusual time for her to be calling her folks. And the judge just hand wrote onto the written motion. We're looking at the one for Janet Reed, and it has a note saying 11/29/24 in Judge Cannone's handwriting. It says, "Denied. Despite the detailed arguments articulated in the supporting memorandum and the oral arguments, the affidavits in support of the motion is insufficient on its face and fails to meet the elements of both the case law that was being argued by the defense and Massachusetts Rule of Criminal Procedure 13A2. And when we look at the order with regard to Karen Reed's father, it is essentially the same thing. The court says, denied, despite the detailed arguments articulated in the supporting memorandum and the oral arguments, the affidavit in support of the motion is insufficient on its face and fails to meet the requirements of the Lampron case and Massachusetts Rule of Criminal Procedure 13A2. So again, Lampron, not land prawn. I just picture a little like shrimp running away. I mean, it is Massachusetts. The Lampron case laid out very specific elements that had to be met, and the defense did a very good job in oral argument articulating where those elements were not met. And if you want to watch all of that hearing in court, I will link it for you in the description. We need to talk about Diddy getting denied, but before we do, a quick word from our sponsor of this episode of Quick Bits. I don't know about you, but it is that time of year when all of my skin feels like it is going to just shrivel up and fall off of my body. But do you know what skin still feels great? If you were like, Emily, your armpits, absolutely. Because one of the things I love about Lume deodorant is not only do I not have to worry about BO, but I also don't have to worry about my skin getting irritated and dried out. And Lume was created by an OBGYN with all of your parts and bits and pieces in mind. Other deodorants just cover up odor. Lume actually targets odor at its source to stop it. And it's clinically proven to block odor for up to 72 hours. So if you're ready to check it out, Lume's starter pack is perfect for new customers. It comes with a solid stick deodorant and the tube cream deodorant. And you can add in a mini body wash that helps target odor before you even put on deodorant, and the deodorant wipes for when you are out and about. Plus, you get free shipping. And as a special offer for all of our listeners, new customers get 15% off all Lume products with our exclusive code. And if you combine that 15% off with the already discounted starter pack, it's over 40% off the starter pack. Use code EDBQB, like the Quick Bits, for 15% off your order at lumedeodorant.com. That's EDBQB at LUMEDEODORANT.com. Make sure to let them know we sent you. Let's get back to talking about Diddy again. Well, I told you all about Diddy's hearing in our last episodes and in the Emily Show podcast on Wednesday. And now we have an order from the judge that came down late on November 27th, right in time for Thanksgiving. And though Judge Subramanian had asked all kinds of questions about where Diddy would stay if he was released and things that indicated maybe he was considering this, I think he did consider. I think this is a very considered order. We're going to look at it briefly, but he had some strong words for Diddy and for the defense attorneys because he's not letting go the legal written on the legal pads just yet. The judge said that no condition or combination of conditions will reasonably assure the safety of the community. This is what the prosecution really focused on, and this is what probation and parole said as well, that there were no conditions that would help assure that Diddy would follow the rules. The judge says the government has presented direct evidence of Combs's violence. This includes video footage from 2016. And then the judge says in parentheses, there is clear violence even in the version of the footage submitted by Combs and text messages between Combs and victim one. The text messages from, quote, the hours and days following the 2016 Intercontinental Hotel incident. Quote, I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. I still have crazy bruising. And then there are others that are redacted even out of the court order. The court goes on to say there is evidence supporting a serious risk of witness tampering. For example, Combs initiated and had unexplained communications with witness one, who was subpoenaed to testify before the grand jury in June 2024, and in fact testified on June 25th, 2024. The court says Combs was represented by counsel during this time, and they have offered an explanation for some of these communications, but they could not explain them all. For instance, Combs' efforts to call and text witness one even after his grand jury testimony, or Combs's deleted texts with the witnesses. It goes on to say further, Combs's interactions with witness one are directly in conflict with defense counsel's representations to Judge Carter on September 18th, 2024, that Combs did not reach out to grand jury witnesses. He didn't do it and he wouldn't do it. So not only has the court used the defense's words against them later on about the legal on the legal pad, but the court went through the entire transcript from the other hearings and said, no, defense, you told Judge Carter that he never reached out to a grand jury witness. And now we have transcripts of where he did that. We have text messages of where he did that. So when I said that things like the legal pad with legal written on it being represented to the judge were going to cost the defense their credibility in the eyes of the court, this is what we're seeing. Is that when the court is combing through things, they are finding other contradictions, and the benefit of the doubt is not going to be extended here. It goes on to talk about the Bureau of Prisons. It says there's evidence that Combs violated Bureau of Prisons regulations during his pretrial detention to obscure his communications with third parties. He paid other inmates to use their phone access codes or PAC numbers to make calls to those not on his approved contact list. He also instructed family members and defense counsel to add other people to three-way calls so that their communications were more difficult to trace. And he used a messaging program called Contact Me ASAP That is not permitted by Bureau of Prisons, and the court does say that he recognizes that that's in dispute. It goes on to say the government gives examples of Combs's communications utilizing these means from as recently as November 4th, 2024, directed to efforts to influence the jury pool or to reach potential witnesses. The court makes no determination about the content of Combs's communications through these channels was improper. However, his willingness to skirt BOP rules in a way that would make it more difficult for his communications to be monitored is strong evidence that the court cannot be reasonably assured as to the sufficiency of any conditions of release. And this is what the prosecution argued. If he's violating the rules, if he's flouting the rules in custody, why do you think he's going to follow the rules out of custody? He'll have gotten what he wants then. The court goes on to say, especially given that they occurred when Combs was seeking bail and when he knew the government's concerns about witness tampering and obstruction were front and center. Not only was he violating the rules, but he was violating the rules when he knew it was brought to the court's attention and when he knew his attorneys were arguing for bail. When he had every reason to be on his best behavior, he still wasn't. But wait, there's more. The court goes on to say, underscoring the court's concern despite defense counsel's assurances to the court at the November 22nd, 2024 hearing with Combs in attendance, that Combs stopped using Contact Me ASAP as of November 16th. The government indicates that Combs continued to use this service as recently as this past Sunday, November 24th. So again, counsel came in to court and said, no, Your Honor, he stopped using that November 16th when the issue was raised. And the prosecution came in and said, no. Even after the hearing, even after the defense told this court that he had stopped using it, he's still using it. Do you think he thought they wouldn't find it? And then we've got to talk about legal and legal. And again, I stress that the representation of what was written on Combs's legal pads is more important than what the actual word was. Him writing legal on top of a legal pad doesn't mean that it can't be searched by the taint team. It doesn't mean that everything in there is automatically protected. He didn't bibbity boppity boo it into some type of attorney-client privilege. The fact that it was written there and represented to the court that it was written there before the government had it, when in reality the photos submitted to the court show that it wasn't written there at that time, that is the problem. It goes on to say, the court further notes that it held an emergency hearing on November 19th to address the government's usage of notes on legal pads recovered from Combs's bunk during a sweep of the MDC. At the hearing, defense counsel advised, quote, all of these legal pads say legal. Yes, they're all marked legal, end quote. After the hearing, the court inquired why, in light of counsel's representation that the notes in issue were on legal pads that were clearly marked as legal, photographs taken during the sweep show no such labels. At the November 22nd hearing, defense counsel admitted that, quote, it has to be the case that as of the day of the search, legal wasn't written on every legal pad, and that they were, quote, not sure whether the pad presented to the court had legal on it at the time of the sweep. The circumstances of this incident and the misrepresentations made at the November 19 hearing where Combs was present bear on whether the court can be reasonably assured that any conditions it imposes will be followed, or whether through inadvertence or active subversion, they will be broken and the community safety threatened. So, once again, the misrepresentations to the court come back to bite Team Diddy squarely. And the court is saying fairly clearly, if even your lawyers are coming to court saying things are happening that are not, saying that you stopped using the Contact Me whatever and you haven't, saying that these were clearly all marked legal when they weren't, how can the court trust that anything the defendant through his attorneys says to the court is true and that the conditions will be followed? So, though the defense attorneys weren't sanctioned, they did seem to earn their client a stay in custody until trial. And while I still think that this trial might get continued past May, I think that Diddy is going to be pressing his lawyers to go to trial in May, whether they are ready or not, because he doesn't want to be in custody any longer. And I think he probably still thinks that he can somehow work his way around this, which I think is fairly unlikely. But we will see, because we've only seen what is in these court filings. And with that, thank you for being here. Thank you for being a Law Nerd. Thank you for being on the Quick Bits. Thank you for all the support of this channel. Don't forget to get the Law Nerd app so you can check out the live court coverage. You don't want to miss this sentencing. It's going to be quite interesting. And with that, I hope you have a great Monday, and I'll talk to you soon. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.